Well, hello everyone. I'd like to thank the Tennessee Physical Therapy Association, its members, the PT Board of Examiners, the many people who served on the task force to put this course together. And a very special thanks goes to the main author and the continuous editor, I call her. That would be to Dr. Kathy Hinton. And Dr. Hinton is at Belmont University. My name is Dr. Alan Meade, and I'm the current chapter president of the Tennessee Physical Therapy Association. And I was on the licensing board from 1992 to 1998, and then served as the consultant from 1998 till June the 30th of 2016, almost 18 years of service as the PT board consultant. So please welcome that you're here today. The Tennessee Physical Therapy Association is pleased to offer this course to help you and to meet the continuing competence requirement for license renewal. Again, this is jurisprudence, and this will help you meet that competency license renewal for that piece of it. In this course, we will cover jurisprudence focusing on the Tennessee Physical Therapy Practice Act and rules and regulations. The APTA Code of Ethics, now that one will be covered in the ethics course, and that will come a little later. So let's get started and we'll get going. First slide, did you know that in Tennessee, PTs and PTAs have received the following disciplinary actions on their licenses? They have letters of reprimand. They have CEU requirements from 40 to 50 hours in ethics, jurisprudence, documentation, supervision, and even in Medicare regulations. I was on the licensing board at this time, and then as I became the consultant, meeting with the board attorney, we saw these kind of disciplinary actions occur. Again, we were looking at making sure that people had educational training in these particular areas that seemed to be a problem for the licensee, and they were having some issues acting in an appropriate manner. So again, these areas come out there to signify further education needed to happen. We've also had quarterly performance reports from their supervisor back to the licensing board to make sure that they were good with observation of their clinical skills and anything else, even in the documentation realm. And did you know that PTs and PTAs have received the following disciplinary actions on their licenses? Civil penalty fines from $500 to $2,000. Here lately, just in the last 2016, 2017, where I have visited to the licensing board, those amounts have also risen to the $5,000 mark. So we have seen some of those fines come available or come upon the licensee. Also, probation from 1 to 5 years. The license was suspended up to 2 years, or the license was just completely revoked. So if you want to know more, anyone can go online and view a listing of the monthly disciplinary actions taken by the health-related boards. Something that you need to know, though, is that there is a national database out there. All states participate. Any licensing board can see the discipline action in their state as well as other states. So if someone's trying to travel to another state, that disciplined action is certainly on their record. And it does follow you wherever you go. Here's the license verification. These are the items that, let's say you're wanting to go practice in another state, or let's say you're coming from a foreign country and want to apply. Again, licensure verification will follow you too. You've got to make sure if you're wanting to go practice in Arizona and you're practicing currently in Tennessee, then you certainly have to, Arizona is going to request that verification of where you've had appropriate licensure in the state of Tennessee. And as you can see here, to your right of the slide, you'll view the the practitioner profile. Tennessee does have a practitioner profile on each one of us as licensees. The other item is on the second one down below there on the right, you'll see view the practitioner profile, and you'll see adverse licensure actions. So you can click on that if you're pulling someone up and see what the adverse licensure actions were. Good reasons to study the law, again, to legally support the decisions you make associated with the physical therapy practice, to avoid finding yourself in violation of the law because I just didn't know. That will not work. You've got to be able to know your Licensing Practice Act and your rules and regulations that clarify the Practice Act in a nicer way, a nicer manner in that case. But you can't just come away and say, well, you know, I just didn't know. I just didn't know that was in there. I didn't know. I don't really remember reading my Practice Act. You really never want to say that. So the other reasons to study the law would be to educate others about the practice of physical therapy. And of course, we don't want any adverse reactions to our record at all as a licensee. We never want that to happen. The Practice Act. The Practice Act is the law that governs physical therapy practice. It's passed by the state legislature. It defines who can practice physical therapy. It defines the legal scope of practice. It defines the standards of practice. I don't mind telling you today that in 2017 and 2018, the Tennessee Legislative Committee for the association is studying and exploring the opportunity to change some things within the Practice Act. So again, it does define the legal scope of practice, and that's a particular area that someone would want to make sure that we're doing all the things that we say we do in our scope of practice. And it also defines the standards of practice. Now, I will tell you that the Tennessee Physical Therapy Association does lobby for the preferred language. We can also submit language as an association, as TPTA can do that. But when we do that, we need to make sure that that language is accepted, and the legislature likes that language, of course. It defines who can practice physical therapy by setting requirements such as graduating from an accredited school, and passing the exam. The rules governing the practice of physical therapy is a companion document to the Practice Act. It's there to help identify, clarify, give some credence to what the Practice Act is all about. The rules provide details not found in the Practice Act. The Practice Act is vague in some areas, so we need this companion document to do that. An example would be in the area of continuing competence. We explain that better here in this document. The Practice Act says that the licensing board has the authority to establish requirements for assessing continuing competence of licensees, and that's true. The rules provide, however, the details as to how this is met, such as the number of hours required and the types of acceptable activities that would count as Class 1 or Class 2. Another example would be supervision. That is explained thoroughly in the rules and regulations. The Practice Act says that the PTs must supervise PTAs and other assisted personnel. So we give some explanation and try to clarify that as well, and we give detail to that. The rules provide the details of what is involved in that particular area of supervision. Accountability. PTs and physical therapist assistants licensed in Tennessee are accountable to both. We are accountable to the Practice Act, and we're also accountable to the rules and regulations, the companion document that I was talking about. We want to emphasize here the accountability to both because the devil is always in the details in the rules. You'll find specific details there in that area. It's interesting. I'll stop at this point. As a PT board consultant, I had the opportunity for those 18 years to travel at least every quarter and meet with the board attorney, or specifically right before a board meeting, a licensing PT Board of Examiners meeting. And what was interesting is to find out that there are so many cases of physical therapists that had violations, may have violated the law in some way. And it's interesting how we, as the board attorney and as the PT board consultant will do, they'll sit down and figure out, okay, is this a violation of the rule or is this a violation of the Practice Act? Again, they do go together and you are accountable for both. The purpose of the Practice Act and the rules is to protect the public. Pure and simple, that's it. It is to protect the public. That is why the PT board examiners is here today. I mean, they are the ones that their purpose is to protect the public, the constituents of Tennessee who receive physical therapy. The members of that board and their terms may be found on the website. And you would go to the health-related boards section and find the Physical Therapy Board of Examiners, and that's where you would find the board members listed there. Typically, the Board of Physical Therapy is referred as the Licensing Board. It's an entity of the state of Tennessee. The members are appointed by the governor. There are 3 physical therapists, and then also 1 PTA, and 1 member of the public, okay? So that being said, the governor, we just had a new law or a new amendment or a law that from the governor that said that not only does he have to take submitted names by the TPTA, the association, for people that are recommended for the licensing board, he himself, as with other health-related boards, he can decide. He can pick anybody he wants to serve on the licensing board. But he still, and his office will still contact the Tennessee Physical Therapy Association in trying to find out who we would recommend to serve in that capacity on the licensing board. The TPTA, the Tennessee Physical Therapy Association, and the Board of Physical Therapy and the PT Board of Examiners, those are one of 2, they're not the same organization. So again, the association is completely different and does not equal by any means the Board of Physical Therapy with those examiners there. The Board of PT is a separate board at this time and has, at one time back in 92 to 98, I remember we had a combination board, PT and OT together, and we had to meet together as a board. Once we met as a separate board in those times, we also met as a centralized, complete board, but that is not the case at this time. The Tennessee Physical Therapy Association's purpose is to serve the PT and the PTA membership. That's their main purpose in all of this. And of course, as I said before, the licensing board, their purpose is to protect the public. All right, the Board of Physical Therapy regulates the practice of physical therapy according to the terms of the Practice Act and the rules. It reviews the qualifications and issues licenses. It interprets issues related to practice, and it certainly takes disciplinary action. It's interesting when you go and you meet with the board attorney and he talks with you about those cases. I used to always say it's bad PTs who have done bad things, or bad PTAs who have done bad things. But those are mostly violations that we're talking about that have been created and have been done in the clinics, so to speak. And then there are also complaints that come from the constituents and the people of the consumers of Tennessee who file those complaints. So that's why some of the disciplinary action takes place. But it's interesting to see some of those cases. I hope to share some of that with you today as I give you some of the examples of what I've seen in my 18 years of service as the PT board consultant. The board administrator, they work for the state. I call it the state of Tennessee. They administer the day-to-day operations of the board. They must follow the procedures established by the board, and they cannot make policy or interpret issues. We want to make sure that you know that for sure. They cannot make policy or interpret issues. So if you call a board administrator for our PT board and they try to give you some information that's clinically related in some fashion or try to give you some policy, they can also, those are areas that may not be in their purview, may not be in their scope, that they can do that. So they can interpret the issues. The other thing is the board administrator usually reports to a unit director, and that unit director oversees several board administrators. And within the health-related boards, there may be, and I may be wrong on this, but there may be an example of a unit director that oversees 7 or 8 boards, and those would be 7 or 8 board administrators. All right, more accountability. In addition to the Practice Act and rules, PTs and physical therapist assistants are accountable to the Board of Physical Therapy policies. And policies are interesting because a policy can be made. For example, let's say I'm driving down the road and some therapist calls me or calls the consultant, the current consultants. We have 4 consultants now. But let's say you as a licensee have an issue and you want to call a board consultant and or a board member of the licensing board. And you're wanting to call and talk to them about a particular area in the clinic that you'd least like to get on the agenda for the next meeting to see if there could be a policy made on your behalf. And a great example of that was I'm driving down the road in Tennessee and I get this call from a therapist that says, you know, I'm in an outpatient PT setting. I'm in an outpatient PT setting and I see diabetic patients in my clinic, and as I see diabetic patients who have total joint arthroplasties, they also have to have glucosometry readings, and can we do that? So that was a question posed before the licensing board, and as you see here in a few minutes, you'll see where it became a policy pretty quickly. And yes, we are allowed to do those glucosometry readings. But that's just to give you an example. The policies from time to time, the Board of Physical Therapy develops policies that attempt to clarify issues regarding the practice of physical therapy. These policies assist in interpreting the Practice Act and rules. And you can see there the link to find those PT policies. And our first one, renewal for licensees called to active military duty. This was done April the 10th of 2003. Special consideration for license renewal for military personnel called to active duty. So I think this was very appropriate to have occurred. The other one that you see there is multidisciplinary health screening. And this one was done in 1998 in September. Health screenings outside the scope of practice are unsafe to the public and may subject the licensee to disciplinary action. So again, making sure it's within your scope if you're going to participate in a multidisciplinary health screening. The policy arose from, this particular policy, it arose from concerns about PTs and PTAs performing activities in health screening fairs that were totally outside their scope of practice. All right, the next one is the lapsed license, March the 10th of 2016. And this one, we've had some issues. I can give you an example of a lot of these. But we had a therapist up in my area of Upper East Tennessee that let her license lapse for 6 months. Just completely forgot it, didn't renew it. I felt like we had to go through an act of Congress to get this thing passed through and to get her back on track. And we did. We were able to do that, but of course there were some fines and fees to pay for that. So if the license is not renewed, a PT or PTA may not practice legally after the expiration date. There's no grace period on that one. So again, making sure on that particular expiration date you practice beyond that, you could really get into some serious trouble and shouldn't do that. A, with your employer, B, with your payers who pay for your services beyond that date when you had an expired license. So think about that. So again, I think there's some serious complications here with that one, with the lapsed license. Here, the book just says there's not a grace period, as I've said before, if you do not renew your license on time. There are some financial consequences, as I explained with the one therapist who let theirs lapse for 6 months. Online renewal is easy and has a faster turnaround time. And the website for online renewal is in the resource list. Now, I will tell you from the online renewal, I do remember at one time that our board attorney had seen several people that signed their signature on the renewal form. This is way back when. But they had signed on the dotted line that they certify that they are renewing. But underneath that signature was a caption that says, it also says that you've completed any and all of your continuing ed and continuing competency hours that were required of you. So when you signed that particular document, and then let's say you're audited and you really didn't have your 30 hours in for continuing competence, then you've just really essentially lied on paper. You have not told the truth at all. So the board takes this seriously. They really do take it seriously. And they took it seriously when they saw a lot of that happening. So again, before you sign on the dotted line or have any of your employers sign on the dotted line for you regarding your renewal process, just make sure that you have all your hours, at least prior to when those are given credit to you, the two years right before the month of your birthday. And we'll talk a little bit more about that in a minute. The lapsed license, again, to continue with it just a little bit, if you keep practicing from 30 days to 6 months, you'll receive a citation, which is reported as a disciplinary action on your practitioner profile. And that's what you don't want. You don't want that disciplinary action. Now, let me say that again, disciplinary action. You don't want that one. You don't want any kind of disciplinary action on your practitioner profile if you don't have to. Again, there may be letters of concern. There may be letters of concern and other letters from the licensing board that address issues. But again, to have a disciplinary action can be serious. And again, when I told you about the verification of licensure and you saw the bottom end of it where it says view the profile, practitioner profile, and then underneath it had adverse actions, disciplinary actions, you can click on there and find that disciplinary action. So again, don't want to keep practicing on that lapsed license if you don't have to. You may apply for reinstatement of the license, regular renewal fee, late renewal fee, reinstatement fee, and a fine of $250 per month. That's up, so that's up there to that high dollar of an amount of $250. Again, going back to the financial consequences of all of this. So, a lapsed license continued. If you practice more than 6 months after the expiration date, your case will go to the Office of Investigations, the OIG, and it goes there and it becomes a real serious complaint of an unlicensed practice and will be handled by the Office of General Counsel, the OGC's office. So, and here again, you could have some severe sanctions placed against you for that purpose. All right, other consequences of a lapsed license. Medicare rules require that physical therapy be rendered by a licensed PT or PTA. Healthcare facilities may have to pay money back to Medicare for services that the PT and the PTA rendered because they were practicing without a license. A, like I was saying earlier, you're going to have an unhappy employer because you did something on their watch. And B, job security. Are they not going to like the fact they're not getting paid? They've just paid you as one of their employees, but Did they lose money? Because the payer is going to ask for their money back maybe as well. So keep that in mind. This could be some serious ramifications all around the loop and circle of this whole issue. So again, it is important to get your license renewed on time. Home health aides. This was a policy on February the 11th of 2005. The monitoring of home health aides by physical therapy practitioners is not in itself a violation of the Physical Therapy Practice Act and rules if no other ethical or practice violations are present. And the book just says, or our manual, and again, I keep referring to the book and the manual, we want to make sure you all don't miss anything regarding jurisprudence. The reasoning was that home health aides are not performing physical therapy tasks, and thus do not fall under the rules of governing the supervision of physical therapy assisted personnel, which require on-site supervision. The monitoring of activities performed by home health aides is considered to be more of an administrative function. And physical therapists may do this. They really may do this, and I'm sure they work that capacity in the home health environment. We'll go next to patient referrals for physical therapy, February the 2nd of 2001. Physical therapists may receive referrals from physician assistants and nurse practitioners. These practitioners can only refer per the physician's protocol, and their referrals are considered orders of the supervising physician. Again, that's key there. Just make sure that, let's say you're working with a nurse practitioner out there in a clinic, it'd be good to ask who the supervising physician is, just for your record, if nothing else. You just never know if you're having to copy or get a signature for certification purposes, what's really required. Is the nurse practitioner's signature required, or is it the physician required, or both signatures required? In polling some of the people that we've talked to in some of these courses face to face, I've gotten it both ways. I've gotten where people have said, Alan, we just rely on the nurse practitioner's signature, or we make sure we get both the nurse practitioner and the supervising physician signature. Again, I think either way is all right. I think I would be a little bit apprehensive with that. And again, I'm giving you my personal opinion when it comes to the Medicare Advantage plans and the traditional Medicare patients. Board of Physical Therapy Policy, finger stick techniques. This is the one I'm driving down the road I was telling you about, August the 20th of 2010. We got it on the agenda right away. It really helped with glucometry readings, Coumadin readings, etc. And we certainly thought it fell within the scope of practice of PT, so long as such activities are performed and called for during the course of a practice. Physical therapy is provided under the Practice Act. So again, those patients, and I've seen it in my clinic, and I'm sure you've seen it in yours, where the patients could pass out on you or have some issues that are probably due to the diabetic medical condition that they have as well. But this is good. This is really good, and it really worked, and it proved to be a good point on our part to get this going forward. I would say, though, you would need to make sure your people, if they're doing this, that you're in your clinics, that they have some form of a sheet or something that describes their competency in being able to perform finger sticks in their clinics. So I would suggest that to happen. All right, continuing competence, March the 10th of 2016. This is failure to comply with the requirement. If a PT has at least 8 hours or a PTA has at least 5 hours. Again, on this piece, you're looking at a civil penalty of $100 per hour that he or she is lacking and must be paid within 30 days. and they need to make up the deficient hours within 60 days. And to me, I think that's tough. I mean, I think it was placed there for a reason, and the reason I think is the 60 days. It's hard to find to make up for some of those hours within a 2-month period. Think about that for a minute. But again, I think the board was serious about this. They wanted people to take their continuing competency very seriously, and that's why they made sure that the amount, the civil penalty was where it was, and also making up the deficient hours within 60 days. The next one, again, is March the 10th, 2016, failure to comply with the requirement. If a PT has less than 8 hours or a PTA has less than 5, the civil penalty of $100 per hour he or she is lacking must be paid. They have to make up the deficient hours within 60 days. And the licensee will be suspended at least 45 days and will continue to be suspended until hours are made up. Now, I will share with you that the 45 days suspension, that's a tough sanction on anybody, and that's where it really will, that's where it will really affect that loop I was telling you about on the employer, the payer, where you're getting paid your salary, the loss of money and revenue. These are things that really could hurt you, and also could certainly have the, well, I hate to say opportunity, but it may give the employer an opportunity to let you go, and because you're not on the job for 45 days. That's just impossible. I mean, I just can't see that happening. So I'm hoping that, I know it has happened. Don't think I haven't seen it, but the board was serious when they put this one forward. Okay, next area, continuing competence, continuing here with the planned learning experiences which occur beyond the entry-level educational requirement for PTs and PTAs. The content must relate to physical therapy. I've been a reviewer for quite some time. I review courses that are submitted, and a lot of you out there are also reviewers, but the first thing we're looking for is it related to physical therapy? Is it related to intervention, examination, research, documentation, education management? Or is it a course on how to improve your 401k financial plan as a professional? That one probably is not physical therapy related, so probably would not be approved as a continuing competence course. So again, the purpose here is to assure safe and effective practice. Continuing competence. The hours are required for 24 months that precede the licensure renewal month. And I can give you just a little bit more example here. Just remember, like my birthday is November, let's say it's in November. Well, they're going to be looking for me 2 years prior to October the 31st. Have I got all of my hours in? That's the best way I know to explain it. So they look at that month prior to my birthday at the end of the month. Let's say my birthday is November the 20th or whatever. Then they're going to look to see I got everything in that I'm supposed to have in for my hours within October the 31st prior to the renewal. I hope that makes sense to you. All right, let's go on. Continuing competence, physical therapist, 30 hours. At least 20 hours from Class 1 activities, and only 10 hours may be acquired online. Physical therapist assistants have 30 hours. That's the new thing that happened as of June 29th. 2016, yes, 2016, that came about, and we have at least 20 hours from Class 1 activities, and only 10 hours may be acquired online. So again, we have upgraded from 20 hours to 30 hours for the PTAs, and that goes back to the new rules and regulations that were put in place in June of 2016. And that date was June 29th. I had that right, June 29th of 2016. So, alrighty. Online. This is where we need to make sure. Looks like hang on one second, let me go back. Here we go. 30 hours, and again, at least 20 hours from Class 1, 10 hours may be acquired online, and I'll discuss online here in just a second. But I must also say to you that ethics and jurisprudence requirement is also included in that 30, and that's 4 hours, 2 for jurisprudence and 2 for ethics, and it's considered as Class 1. So for current licensees, this is required every license renewal cycle, okay? Every renewal cycle. So for new licensees, within the initial period of licensure before the first renewal, then you go to every license renewal cycle. But this is important because PTs and PTAs, 4 hours of ethics and jurisprudence, for current licensees that are out there in Tennessee, you're required every license renewal cycle, so that's every 2 years now. And then for new licensees, that's you new therapists, new graduates, you're within the initial period of licensure before the first renewal cycle. Then go to every license renewal cycle thereafter. So that's what we're looking for. So in your first year, it's not like you all have to rush out as a new grad to take the ethics and jurisprudence course. Just remember, you've got to do it before your first renewal cycle that comes up in 2 years. So again, I would say to you and encourage you sometime, maybe toward the end of your first year as a practicing PT into your second year, make sure you're going to get your E and J requirements completed. All right. I'm back on here with continuing competence. Let me explain a little bit about online. It generally refers to a course accessed on the internet. Online does not include courses that are interactive, which require answering a quiz or answering quiz questions throughout or require successful completion of a written exam. It's real time with opportunity for interaction. Again, it could be a webinar where you've got a speaker, you're live with that webinar, and that would be considered as face-to-face. So that one with face-to-face, you would have an opportunity to chat in the chat box back and forth with the speaker. And I'm trying to give you some definitive areas of where online and where face-to-face would be. So face-to-face would be, of course, your regular hours, and the online you only get 10 that you can use. So just be aware of that. So again, let me just repeat, online does not include courses that are interactive, which require answering quiz questions throughout or require successful completion of a written exam. It's real time with opportunity for interaction back and forth. We talked about ethics and jurisprudence there, that requirement. And then we're going to talk now about Class 1 activities. You have external and internal peer review. Again, these are activities, these are highlights of what constitutes Class 1 activity for continuing competence. Some of these activities have limits on the number of hours that can be used for credit towards them. Again, I urge you to consult the rules directly about a given activity that you've completed or that you're thinking about being considered. If you're not sure if a course would be accepted as Class 1 activity, you can submit to the TPTA, the Tennessee Physical Therapy Association's approval process. The peer review credit is intended for the person receiving the review, not the person providing it. So it'd be like me providing the review on my PT providers that work with me, and it would really go for the person I just reviewed, the provider themselves, not me, the person conducting it. The other areas would be approved continuing education courses, APTA or its sections, the TPTA, the accredited PT or PTA schools that are in our country and in our state for sure. University credit courses. Those of you that have gone back and actually earned university credit courses, again, it pertaining to physical therapy. Presenting continuing education courses. That would be you're going to speak and take your course on any topic, and you're teaching that course at a state meeting or at the APTA, you're going to get credit for that. Author peer reviewed research, and then adjunct teaching in physical therapy or a PTA program. I currently am an adjunct faculty member at East Tennessee State University. So again, those things count for you. Continuing with continuing competence is Class 1, is clinical specialist certification or recertification by the American Board of Physical Therapy Specialties. Other clinical specialist certification, the McKinsey, NDT, Ola Grimsby. It could be several others that are not mentioned here. It could be an advanced degree. It could be clinical residency program. So the residency programs are popping up everywhere. So this is great. So these are things that count as Class 1. Class 2, self-instruction reading literature. I never will forget, a person came to me and said, well, I've read all these articles and I'm going to get 8 hours for it. So they printed their 8, they were audited, by the way. They just sent in their 8 articles of reading, and that didn't cut it. So again, they failed the audit. They had to find some other areas and means of what they could submit. So again, you can do self-instruction reading literature for sure, but just make sure that you've documented well what the title was, who the authors were, and you certainly can do so many of those, and then make sure you put that in some format that if they ask you when you're audited, you can submit what you have read in the literature. Attending educational sessions that do not meet Class 1 criteria. That would be educational sessions maybe that are within the employer that's physical therapy related. Could be educational sessions maybe at the federation level or the FCCPT, or just educational sessions that do not necessarily meet the Class 1 criteria, but may have some inclination about physical therapy or it pertains to PT. You can be a clinical instructor. Some of you serve as CIs all over the state, and you get credit for that. Study group participation. This is where some people have formed what's called the Journal Club. I never will forget, we tried a Journal Club and an orthopedic study group. It involved orthopedic surgeons, it involved PTs, it involved OTs, and we came together on a certain night of the month, and we documented it, and that was counted as a study group participation. Attend or present in-services. When you attend or present in-services, I love giving this example. So let's say you're doing your lunch in-services at your employment place, and physical therapists has come in, or somebody's come in for wound care, or someone's come in for an orthopedic in-service to present to you and your PTAs, or athletic trainer for that matter. All I know is you need to document it well on a one-page sheet. You need to have the speaker. You need to know the topic. You need to know the time, how much was spent time-wise. And then you need to list all the names that were on that record for that day, who attended. The attendance record is key to that. And then you get so many of these in-services, like 8, and it counts up to 1 hour of Class 2. So those are still legitimate hours that you can gather. Let's say you serve as an APTA service in some capacity as a delegate. You're in the House of Delegates, or you're on some committee. You're on a board, or with a task force. Again, that's service to the association in some capacity, and those count. At this point, we are going to take about a 5 to 10 minute break. The next area is continuing competence on the unacceptable activities. Your CPR training, your OSHA, your TOSHA, your safety courses, meetings for policy decisions within your organization, non-educational sessions or entertainment activities at professional meetings. In other words, going to a particular, let's say you're going to combined sections meeting and it's a non-educational session or an entertainment venue, then you're not going to get credit for that. Visiting the exhibit at combined sections, and that's all you signed up for was the social registration. You're not going to get credit for that at those conferences. So those are areas of unacceptable, Class 1 or Class 2. Then we have documentation must be retained for 5 years after completion of requirements. Examples of documentation may be found in Rule 1150-1-.128D. So again, you'll have examples of documentation there. You do not have to submit documentation every time you renew your license. However, I want you to know the Board of Physical Therapy randomly audits 5% of the renewals each month to verify compliance. So that does happen every month. I do know from the licensing board perspective, they'd like to increase that 5% up to 100%. So I think that puts us all on guard. We need to make sure that we're getting our hours in comfortably and also within a timely manner and efficiently. So again, if that board ever makes that move to the 100%, we're all susceptible to an audit. And on documentation, again, for audit purposes, let me just say this. Just my practice, what I try to do is I usually use a manila folder envelope and I'll label it 2016 or 2017. I think mine goes all the way back to the year 2000. So I've got every certificate I've ever earned in each one of those yearly folders, and it really helps me because that way, as soon as I get the certificate, that's key to going into that folder in case you get audited. Some of you maintain it maybe in your cell phones. I don't know. I do know that the people that are part of the audit process at the state level, at the administrative state level, they are looking for a certificate. They're not looking for papers a mile long or looking for 6 pages of an article that you read and that counts as one article that you read. They don't want to see that. They want to see that format I was telling you about for that. But then on anything else that you can give them certificate-wise, you need to do that. So look for those certificates. Make those forms into certificates. That kind of helps your whole process part. They love that too. They like to be able to do that. So, retirement of a license. You may apply to convert an active license to an inactive retired status. You cannot practice physical therapy or imply that you are actively licensed in Tennessee. You do not have to pay the renewal fee. So there may be a situation, you all, where someone is moving out of the state but does not want to give up his or her Tennessee physical therapy license completely. In that case, they need to move back might arise. So again, you will find people coming back maybe after 6 years and they want to reinstate. So that does happen. But there are provisions in the rules that for retiring and reactivating the license. So again, pay close attention to those. Reactivation of the license, submit a written request. Fees for renewal and reinstatement. Complete the continuing competence requirements. Board of Physical Therapy has the discretion to require additional education, supervised clinical practice, or successful passage of licensure examination. I have seen the board in the past do some things that would say to the licensee, well, it looks like you're wanting to be licensed, you hadn't been here for 10 years, you'll have to pay all the fees, but also can we see how much continuing ed you have done in those 10 years? And then they might have to have a supervised clinical practice because they've been out of the scope of PT for quite some time. So that will happen, and that is usually to the board's discretion. They are the final arbiter to that decision as to what happens. Next area, scope of practice, use of direct thrust, direct access provisions, and dry needling. Again, these are areas. Dry needling came about as of June 29th, 2016. And I can somewhat give you a story of all of that as well, and how that came to be. So we'll let you know there where we are. All right, use of direct thrust. Scope of practice of physical therapy shall not include the performance of treatment where the PT or PTA uses direct thrust to move a joint of the patient's spine beyond its normal range of motion without exceeding the limits of anatomical integrity. You got to remember, this is something that we had to agree to. We were trying to fight for our direct access language, and when we did, we had to put this piece in regarding this, but I guess to please some of the chiropractors at the time. The other thing is, we know it's not beyond its normal range of motion. That's not our intent. So as I was telling you earlier in the part of this presentation, we're looking at all of this Practice Act language, re-languaging some things that will help us maybe futuristically down the road so we can identify this much better. Direct access provisions. PTs must practice with a referral from a doctor of medicine, chiropractic, dentistry, podiatry, osteopathy. It's referred to as doctor on the following slides, okay? And except for the exemptions described on the following slides, so we'll look at those too as well. Direct access provisions for initial evaluations. Initial evals, that's where you're going to do your initial eval. Provide assessments and instructions to asymptomatic persons. Emergency situations. We're good here. We're good here at this piece of it. Providing treatment in the absence of attention, should it result in health and in serious jeopardy or serious impairment to bodily functions, serious dysfunction of the bodily part. So we're not held accountable for that. I mean, we are, but again, if we act in the emergency situation, we're good to go there. Again, we're trying to potentially clean up this language as we go forward. So look for more to come when it comes to direct access. Direct access provisions. Patients want PT to inform his or her doctor. A patient comes to your clinic with low back pain and wants you to let his doctor know that he has come to physical therapy. You must inform his doctor of the initiation of PT services no later than what? That's right. You would say no later than 5 business days after the evaluation. 5 business days. You must then consult with his doctor within the first what? 6 visits or 15 business days, whichever comes first, or no further treatment can occur. And again, this is where sometimes we have some confusion regarding direct access language. Another piece that we hope to clean up as well. But it's been confusing. There's been a mismatch between calendar days and business days. What does that really explain? The direct access provisions may be found in the Practice Act in your handout or the thing that you've already downloaded. If you're going to see patients in a direct access manner, you need to carefully read the provisions of the law to make sure you are in compliance. And hopefully these examples will help to clarify. Consultation is defined in the rules as a meeting that's conducted either face-to-face or by someone, or by some other medium, such as, but not limited to, telephone, fax, mail, electronic means, wherein 2 or more health professionals discuss the diagnosis, prognosis, and treatment of a particular case. So that's consultation. So we're often asked what's meant by consulting or consulted. This is how it's defined in the rules. So there you go, how it's defined for the practice of physical therapy. All right, a patient comes to your clinic with sprained ankle from slipping on ice. She tells you she just moved to town and does not have a doctor. You have her sign a consent form and place it in her patient record and tell her that you will not be able to treat her longer than blank. How many days? 30 days, since she does not have a doctor. You provide her with what? A list of doctors. So the consent form confirms that the patient does not have a doctor. You're already finding that out. So the correct answer again is 30 days. And you had 30 days since she doesn't have the doctor, so you can't go any further than that. All right. Patient comes to your clinic with a sore neck from a motorcycle accident. He tells you that he does not want you to tell his doctor about physical therapy. You have him sign a consent form and place it in his patient record. You tell him that you will not be able to treat him longer than blank. What do you think that is? That would be 30 days, unless you consult with his doctor. Again, guys, I'm hoping that as we move and make changes in 2018, 2019, the Practice Act, then we'll try to clean up all of this language. The patient was seen by his doctor in January for lateral epicondylitis. He comes to physical therapy in August with the same problem, but he's not been to his doctor for it. True or false? The physical therapist must obtain the patient's consent to inform the doctor of the patient coming to physical therapy. Let me repeat. The PT must obtain the patient's consent to inform the doctor of the patient coming to physical therapy. True or false? That is false. Direct access provision, patient progress. If no substantial progress is made in 15 calendar days or 6 visits, the physical therapist must stop treatment and refer the patient to a doctor. For patients previously diagnosed with chronic neuromuscular or developmental conditions by a doctor, this provision does not apply. So what would I be talking about here in that particular regard? Maybe it's the neurological pediatric patient that's out there. The school system may be an area that we're talking about regarding the neuromuscular developmental conditions. So again, that goes to that particular topic on that issue. Direct access provision, summary of maximum length of treatment. This is the summary of maximum length of treatment. No limit once a consultation has occurred, unless the patient's not making progress due to patient request or patient having seen the doctor within the past 12 months for the problem. Again, see how confusing this all is. It really is. So again, we hope to clean all this up. The other thing is the other summary of maximum length of treatment is 30-day limit on treating the patient if the doctor has not been notified of PT services if the patient does not have a doctor or the patient does not want the doctor notified. So again, those are issues that we have to be cognizantly aware of when it comes to whether they want their doctor to know or not know. So, all right. If a patient returns to physical therapy within 90 days of treatment with the same complaint, the PT must refer to the appropriate healthcare provider. For patients previously diagnosed with chronic neuromuscular or developmental conditions, but this provision does not apply. Again, for recurring condition, recurring. And you may find that a lot more in the area that I was telling you about earlier, school systems, pediatrics, the more neurological developmentally patients that fall in this category. All right, to treat patients without referral, a PT must meet one of the following 3 conditions. Currently, this reads like this: a master's or doctorate degree in physical therapy and 1 year of experience, okay? 2, successful completion of a residency or clinical fellowship approved by the board, APTA or AAOMPT, okay? American Association Orthopedic Manual Physical Therapy, or the American Physical Therapy Association is what that is explaining. A board approval residency or clinical fellowship is one that is approved by the APTA. Again, it has to be approved by one of these two groups. There's no time limit on when you may have done this for acceptance. Number 3, 3 years of experience and completion of a 15-hour physical therapy screening course approved by the board and offered by an accredited university. And that's where we find most of this. We will find the medical screening and differential diagnosis courses are usually taught at the university level. Therefore, they become an automatic. It's an automatic accreditation. Hopefully, you're getting the 15 hours that you need so you can get that requirement taken care of. From the manual, it just says another part of the position statement adopted to the Board of Physical Therapy relates to a 15-hour course and is provided below. You may want to go over the main points here, and that is any physical therapy screening course is offered by an accredited university, that would count. Any physical therapy screening course that meets the following criteria: taught by a health professional who holds a regular or clinical faculty appointment in a physical therapy educational program and consists of at least 15 contact hours. Identifies the signs and symptoms of systemic disease that are not appropriate for physical therapy intervention without prior examination by a primary health care practitioner, including signs and symptoms of cancer and diseases of the cardiopulmonary, neurological, and musculoskeletal systems. C, teaches participants the decision-making process for determining when patients and clients require further exam or consultation by a physical therapist or referral to another healthcare practitioner. And D, integrates the process of making an appropriate and timely referral to another healthcare provider into physical therapy exam and evaluation. Important thing to note about this policy is that the board did not put any kind of retroactive time limit on this. This means that you've had a course that meets these conditions any number of years ago, you may meet this qualification of this 15 hours. I'm back, and now we're on the dry needling area, the educational requirements. Give you just a little bit of history right quickly. We had a physical therapist who wanted to practice dry needling in Tennessee. He was coming from Colorado. We asked him to come to the licensing board. I know I asked him to come and present to the licensing board. Some of our states that were surrounding Tennessee, of course, were practicing or had some form of dry needling in their practice, in their scope of practice. He wanted to make sure Tennessee got it, and he did a tremendous presentation. Once he did the presentation, and we got our other resourceful information, come to find out our board at that time, the licensing board, decided, along with the board attorney, to do a policy. And the policy was to allow dry needling to be within the PT scope of practice. And that's how this all came about. Well, then that happened, and board attorneys changed. And I think this new board attorney was there for about 2 times. And after the second time, he had asked the licensing board to take this down off their website, that they had had complaints from the chiropractors and also some complaints from the acupuncturists. So we had to remove it from the website where we had just put it up, saying that we could do dry needling in Tennessee. So it was a very short time period that happened. So then our current, our chapter president at that time, Dr. Scott Newton, and the Tennessee Physical Therapy Association felt like this was such a strong issue that we needed to legislate this process through. And we did that within a year's time. And so now we have dry needling in Tennessee, and we use some of the language that Arizona used, and it's been real exciting on how we pull that off. The thing is, the dry needling piece, you still have to you have to go through a provider that's been approved to be able to say that you've gone to that course that's been approved by the licensing board of that particular vendor who provided the course. So again, I'll get into more detail of that, but we do have it as of June 29th, 2016. So we are excited about that process. Matter of fact, Tennessee was recognized and given honors for its efforts in the area of dry needling and how we legislated the process through. So we were excited about that. The educational requirements, all instructions must be in person, a combined 50 hours of instruction in musculoskeletal, neuromuscular systems, anatomical basis of pain, mechanisms, chronic pain and referred pain, trigger points, the universal precautions that are always there. These are always generally satisfied. All of these areas that I've mentioned are generally satisfied in the physical therapy school, where you've been in school and graduated as a DPT. You've had all of this information in your didactic and curriculum. So, okay. Next slide. 24 hours of dry, these are more of the specific requirements, the educational piece. 24 hours of dry needling, specific instruction in dry needling technique, dry needling indications and contraindications, documentation of dry needling, how you do that, management of the adverse effects, practical psychomotor competency, and the OSHA's blood-borne pathogen protocol. Well, we certainly should have that piece already, but we want to make sure the 24 hours encompasses all of these items. And there are courses out there that have been approved by our licensing board that are considered as appropriate providers to take this course from. Dry needling courses must specify what anatomical regions are included and describe whether it offers introductory or advanced instruction. It must be pre-approved or approved by the licensing board or its designee. We had a task force that was put together. The person that chaired that is part of our licensing board today. His name is David Finch. David Finch is part of that task force that put this together on the dry needling to bring it to the licensing board and how to approve providers and vendors who actually conduct these courses. So again, I'll go back and say, if you've taken a course that's not approved by the licensing board, you may submit information for approval 30 days before the next board meeting. But just remember, there are vendors and providers out there already that have already been approved. The provider must provide to the licensing board administrator the name of the course provider, the synopsis and description of the course, a copy or description of any course materials used, and then the physical therapist who obtained dry needling training in another state or country, they must provide this same information to the licensing board administrator for approval. Again, I think they probably place this in your file, that you have some dry needling competency and that you are a certified dry needler. All right, dry needling. A newly licensed PT may not practice dry needling for at least 1 year from the date of initial licensure unless he or she can demonstrate compliance with the educational requirements through pre-licensure educational coursework. So let me stop here and say that they are doing this now. We have the University of Tennessee, Chattanooga, and also Belmont University has also gone through the process where their new physical therapy students that are to be new graduates have to participate in this type of a program and in this educational series of dry needling throughout their curriculum. And we're excited about that being in their coursework. So again, when they come out, this would certainly pertain to them. So again, they would have no problem demonstrating compliance with the educational requirements. Dry needling may only be performed by a PT and may not be delegated to a physical therapist assistant or support personnel. That's simply put, and that's exactly the way it is currently. All physical therapy patients receiving dry needling shall be provided with information that includes a definition and description of the practice of dry needling and a description of any risk, benefits, and potential side effects of dry needling. The next area is conduct that may result in disciplinary action. And again, I'll share some examples of what I've seen in my 18 years of consulting to the licensing board. Some really weird examples. I hate to say that, but there are some ones that are way out there. So I will give you some of those examples. But let me go forward. These would constitute, again, conduct that would result in disciplinary action. Scope of practice. Practicing physical therapy in the violation of a practice act or any rule or written order adopted by the board. So in other words, you're not following your scope. Practicing or offering to practice beyond the scope of practice. Let me give you an example of that. We had an example of a person wanting to do spider veins in his practice, and we had to discipline that physical therapist. He was creatively advertising the spider vein removal, and that certainly was not within the scope of practice. So that came up under my watch as a consultant. Failure to maintain adequate records, such as physical therapy evaluation, physical therapy treatment diagnosis, plan of care including desired outcomes, treatment record, results of interventions, what you've done for the patient, discharge plan, and the patient identification information. You would not believe how many cases have come before the board where people just blew it off and they've gotten mad at their employer, they've walked off the job, and have not completed or maintained their adequate records. They've not done that. And that really comes back to bite you. And that really has happened. Maybe, I want to say 3 or 4 times, at least while I've been, was the consultant. So that did happen with maintaining adequate records. You've got to do that. I know people now, when they think they're going to resign and move on to another position, they certainly are given a window of opportunity. At least I think we do, but I'm sure other clinics do too. They give a window of opportunity to complete any and all records of the clinic. Another example, let me go back for a second, guys, on offering to practice beyond the scope of practice. The manual talks about the question of physical therapist assistants doing sharp debridement and manual therapy. Often arises, that question does come up. So the American Physical Therapy House of Delegates does have a position statement that these interventions are to be performed only by the physical therapist. But there's nothing in our Tennessee Practice Act that would prohibit PTAs from doing this, either the manual therapy and or the sharp debridement, wound care management. However, the APA documents could be used to document the standard of care. Again, when we talk about violations of the Practice Act, violations of the rules and regulations, one of those is that the person is providing substandard care. Well, this, with the APTA labeling like it did, you're looking at it saying, well, how come it's the standard of care that PTAs don't do it? So again, you've got that barrier you've got to cross should that come up before you. All right, let me go on through. We'll go past the one we just talked about records. A PTA on this one did not document on 40% of her patients. Her license was put on probation for 3 years and had to take extra continuing education on accurate, timely documentation. So there's a case of that one. All right, here's the Board of Physical Therapy recognizes that in some situations, a patient's discharge is out of control of the physical therapist. A discharge plan, evaluation, or summary is required for every patient record. To give you an example of this one, we had a particular PTA that I was called in as an expert witness to review a file. A patient had complained about the fact that this particular PTA had abandoned her and had deserted her. This physical therapist assistant also taped this patient's legs together and told her to leave the tape on for 7 days, and the patient complied or tried to comply. Anyway, there was some anger and resentment from the patient. And also, this particular PTA wrote the discharge plan and discharge summary. So as an expert witness looking at this case, and believe me, it was pretty big, come to find out, as you're looking at it, not as the consultant, but as an expert witness, you're looking at, for any and every 30-day reassessment, you're looking for clinical supervision of the PT over the PTA during this time level. So come to find out, this particular individual wrote the summary. We found out later that there were 3 physical therapists that were over this particular case that did not do the 30-day periodic reassessments or the reevaluations. They weren't considered done at that point. Then one of the physical therapists, who was being the supervising PT toward the very end, decided to just copy forward or copy the PTA summary, the summary from the discharge summary from the physical therapist assistant. That's what happened. So we knew that was a violation. So lots of things went on that labeled 3 people with violations, and of course the PTA was labeled with multiple violations. So it follows you up from the PTA all the way up to the PT because of supervision status. Again, here's the one I was talking about, substandard care. This is a description of what constitutes substandard care by a PT due to ignorance, incompetence, or a deliberate or negligent act or failure to act. For this one, I can give you an example, because let's say you as a physical therapist accidentally fracture somebody's wrist, their radius or ulna, and the patient sees it as being deliberate, or the patient sees it as being a negligent PT act, and due to your ignorance, then they're certainly going to make a complaint against you, or could, or may not make a complaint. But again, this would be the violation it falls up under, is substandard care. Okay. Same thing for PTA, which it is exceeding the authority to perform the task selected and delegated by the supervising PT. Overutilization, underutilization of the PT, number of visits, overutilizing, going way beyond. It was interesting to go to an APTA event about 3 or 4 weeks ago, and they described that the number of visits as they've looked at all of the G codes and looked at the complexity evaluation codes of low, moderate, and high, they have found, in just the data from 2014 to 2017, they have found that a patient was seen in the clinic 219 times. I think there might be some overutilization at that point. So again, 219. Other substandard care, intervention unwarranted by the patient's condition, treatment beyond the point of reasonable benefit, abandonment, there's the one I was mentioned that had several issues with it, periodic reassessment, the abandonment issue came up, failure to practice in accordance with the standards in the guide to physical therapist practice. You got to remember, if you're ever caught in a complaint and the complaint goes forward, don't think that the resources won't be used to look at the guide to physical therapist practice, looking at that kind of information of what they can either place against you, or maybe it might be in favor of you. So, all right. Inadequately supervising or delegating duties which exceed the scope of practice for support personnel. Okay. PTAs, assistant personnel, students, volunteers, knowing exactly how and when to use those people, how to delegate duties accordingly. But if you're doing it inadequately and not appropriately, you could get in trouble for that. Aiding or abetting a person not licensed who directly or indirectly performs activities requiring a license. Again, your assistant personnel is your physical therapy technicians or your aides. You know who your students and volunteers are. Other assistant personnel may include your athletic trainer, your exercise physiologist, your massage therapist that works in your clinic. Again, there again, they would be considered under the purview of assistant personnel. Okay. You got to remember also, the manual also talks about this may involve issues of inadequate supervision. PTs and PTAs can be charged together with aiding and abetting an unqualified, unlicensed person, such as an aide or a tech, to practice physical therapy. Assistant personnel, students, and volunteers must have on-site supervision. The supervising of the PT or PTA must be continuously on-site and present, immediately available to assist, and maintain continued involvement in appropriate aspects of each treatment session. So, a verbal opinion from the Office of General Counsel defines the word immediately as instantly available, not on another floor or down the hall. A common sense guideline for immediately available is that the supervising PT or PTA can see or hear what is being done during treatment. We've heard objections to these supervision requirements for students on their final clinical rotations. So the students do come back and tell what they've seen and what they've heard. Inadequate supervision. Supervision of students. On-site supervision. Clinical instructor must have 1 year of experience. Volunteers on-site supervision. They may not provide physical therapy to patients. They're usually there maybe if you want them to possibly change a bed or help you in some way bring a patient back that says hello to you and brings them back to an area. However, usually a tech or an aide will do that. But volunteers are usually there to try to do their service, get their time in, and eventually apply for PT school. Okay. Allowing volunteers to treat patients is a huge liability issue. If the patient is injured by a volunteer who is not supposed to be treating patients at all, the patient would have a very good claim in a malpractice case. All right, let's go back and see if we can answer some of these questions. A PT must perform the evaluation and develop a written or verbal treatment plan, including goals, frequency, and time period of service. What's your answer to that? Written. Must be a written treatment plan, including the goals, frequency, and time periods. All right, a PT must perform and document reevaluations, assessments, and modifications in the treatment plan, what? Every 30 days. Okay? For patients seen longer than 60 days, a PT must inspect the actual act of therapy services rendered by a PTA at least what? Every 60 days. A PTA may see the patient for the discharge evaluation as long as the PT signs off on the note. True or false? Well, that's false. I gave you an example of that earlier. A PT may not supervise a PTA that is delivering services at a site further than blank 60 miles or 1 hour from PT. A PT may currently supervise no more than the equivalent of blank full-time PTAs. What's your answer to that? That would be 3, yes. You may want to say here that a physical therapist may concurrently supervise no more than the equivalent of 2 full-time assisted personnel or aides. So a PT can have the 3, but you can only do about 2 other assisted personnel, like your tech or aide in that case. And again, this is all at the same time you're supervising the 3 PTAs. The PT and the PTA are equally responsible and accountable for carrying out the supervision provisions and the rules. True or false? That is true. This is a case 1. After patient evaluation in January, physical therapy delegated treatment to a PTA. PTA treated per original treatment plan 2 to 3 times a week until October. The PTA, you got to remember, January to October. PTA performed assessments and status reports monthly for the MD, except in April when this was done by a PT. PTA documentation was incomplete and unsigned at times. Okay, you got that scenario in your mind. Okay. Did the Board of Physical Therapy take disciplinary action against the PT? Yes. 1 year probation, $2,000 fine, 50 hours of education in ethics, jurisprudence, documentation, and supervision. The PT was disciplined for the violation of inadequate supervision of assisted personnel, failure to reevaluate on those 30-day periodic reevals, failure to maintain adequate patient records. Again, that was heavy. Think about that again. 50 hours, 50 contact hours of continuing ed in ethics, jurisprudence, that's hard to get. That's hard to find. So you can tell this was a real strong disciplinary action against this physical therapist. Did the Board of Physical Therapy take disciplinary action against the PTA? You darn right they did. I think they did. Yep, they did. 1 year probation, quarterly reports from a different supervisor, 50 hours of education in those areas I've mentioned, and discipline for those violations there is listed. Practicing beyond the scope of practice, engaging in substandard care by PTA, and again, exceeding their authority to perform the task, and failure to maintain adequate patient records. Okay. All right. A PTA performed an FCE evaluation, functional capacity. Did the Board of Physical Therapy take disciplinary action against the PT? Yes. This is my area that I teach and talk about a lot on functional capacity, industrial rehab, and medicine, occupational medicine. This particular PTA took probably a course on FCEs. He was told to cease and desist from performing FCEs. He agreed to the board order to do that. He also was told to do continuing education related to the scope of practice of PTAs. He was disciplined for that. He was engaging in substandard care by PTA. He was doing an evaluation. He wasn't assisting the PT, or that would have been different, but he was doing the full-blown PT or FCE. That being said, this gentleman took it a step further and didn't hold to the agreed order, and he went out and did it again. So guess what? He lost his license. So yeah. So this person did not. Boy, when you go against a board order, you've really taken a big chance by doing that. So, okay. Ethics, failure to adhere to the standards of ethics of the physical therapy profession. The APTA Code of Ethics for Physical Therapists is there. The rules have adopted that. The APTA Standards of Ethical Conduct for Physical Therapist Assistant are also there. They not only must obey the law, but through the law they are held to high ethical standards. Even if you're not an APTA member, you're still bound by the APTA ethics documents for PTs and PTAs. So please remember that. Many of the physical therapists and PTAs disciplined in cases we discussed were also cited for failing to adhere to the ethical standards of the profession. And again, you can find these documents. They've been, if you've downloaded the course here, you're certainly going to find those in your handout or in your downloadable document. Okay. Practicing while impaired by drugs or alcohol, DUI conviction, you have to report on a license renewal. License may be put on probation. You may have to be put on monitoring by the Tennessee Professional Assistance Program, TNPAP, and you may jeopardize credentialing by insurance companies and their willingness to reimburse for your services. This is key. I've got an example of what we did when you're not reporting things to the licensing board. A gentleman did not report to the licensing board his DUI and drug paraphernalia issue. Clearly told to do so, and after this person didn't do that, went ahead and took their PTA exam and was told to report this issue early on in January, February, March. Didn't do it. Next thing you know, takes the exam in June, passes the exam before any of his other constituents in his class, passes the exam, but is put off from practice because he failed to report this issue, put off from practicing in a new job for the person till October. So he took the exam in June, couldn't practice till October. So that should tell you you've got to report anything like this to the board. Again, they're helping with peer assistance, and that's critical here. And we like that. We want TNPAP to step in and help the individual. That's what they're there for. But you've got to let your licensing board know. All right. Having been judged mentally incompetent by a court of competent jurisdiction, disciplinary action taken against a license held in another state. Again, I told you the databases follow you. They will follow you, and I'll know what happened in Kentucky if you're trying to come to Tennessee, or our board consultants will know that. Failure to meet continuing competence requirement. On this one, I'm going to tell you that I met with the board attorney, and there were about, 60 complaints of people that were PTs and PTAs that blew off the 60 hours. They blew off the 60, I didn't mean to say 60 hours. There's 60 files that blew off the 30 hours, and several PTAs that blew off 20 hours at the time of their continuing competence requirement. You can't do that. And I think the board really, at that point, wanted to make this serious. And they got angry. They got upset that people weren't abiding by the rules and regulations on continuing competence. That being said, they made an issue of it. So again, that's why we have auditing like we have it now. And again, if it goes to 100%, we're all under the radar, so to speak. Patient confidentiality, failure to maintain patient confidentiality without prior written consent or unless otherwise required by law. Suspected child abuse must be reported to Child Protective Services. Suspected abuse of dependent older adults and people with disabilities must be reported to Adult Protective Services. If you're a physical therapist or a PTA and you're treating a patient and you know and you suspect elder abuse or in pediatrics, child abuse in some form or fashion, you see it firsthand, whether it's verbal, physical, mental, whatever, you still have an obligation to report this. And if you don't, they've been under your practice, they've been under your jurisdiction as you're treating them. Something later comes down the pike and they say, well, I went to physical therapy, I can't believe they didn't see that. So again, make sure you report this. Sexual misconduct. Engaging in or soliciting sexual relationships, whether consensual or non-consensual, while PTA relationship with a patient exists. Again, that's getting with patients. You don't want to do that. Making sexual advances, requesting sexual favors, engaging in other verbal or physical conduct or physical contact of sexual nature with patients, intentionally viewing and disrobing the patient, viewing a patient as they're disrobing, and it's not related to care. I never will forget, I had a patient for cervical problems, and the physical therapy technician went in, pulled the curtain back. He was completely naked, and from all the way up. And of course, that embarrassed her. So we certainly had to say, you can put everything else back on, but we need to see your take your clothes off just down to the waist and do that. So again, don't make sure you're not setting yourself up for any kind of an incident or failure. I do have some examples here of this. We did have a particular gentleman was treating a patient in the prone position, a female, and was commenting on how he really liked the color of her brassiere, and that it was purple, and that he thought that, and he flipped it a couple of times. And you just don't flip someone's colored brassiere. Another area was in women's health. We had a case where two females came forward and talked about being violated and being raped. And anytime you see the words, guys, anytime you see the words violation and or violated or raped, that reaches the level of very high investigation level. It goes to the top of the crop of everything. They stop what they're doing. They go investigate that immediately. Others, watching student athletes disrobe, pulling their shorts down, those kind of things. The mother noticed this of her daughter. Those kind of things have happened. Fondling, anything in the clinic like that, whether it be male or female. Those are just some issues that have come up that I've seen under sexual misconduct. I will say, under supervision is probably the number one thing you might see that may be a problem when it comes to violations. But the second one is sexual misconduct. That's what I have found to be a problem. And then maybe inadequate records is number 3, failure to keep inadequate records. Just real quickly, just a couple of other examples to use here. 2 physical therapist assistants were married to each other. They, outside of their work, they had really gotten to know one of their patients really well, who was an elderly couple. The elderly couple was trying to treat the husband who had a CVA, a cerebrovascular accident, and this couple of PTAs got extremely close to the couple, even doing their grocery shopping and other shopping and getting their medications renewed and refilled and all of that. They did everything outside of what they should do from a clinician standpoint. Anyway, they were placed in this couple's will and testament, and the other 4 children that belonged to this couple were written out of the will. So this happened, and never will forget that. So these 2 PTAs were brought in for violations. Another one, a physical therapist had murdered her husband in self-defense, and that was a hard one for us to decide on the licensing board level at that time, whether the self-defense had to stick pretty well, and she was able to practice again as a PTA. Lots of domestic violations; those can really be problematic for you. Other things like not paying child support, that's a big one, a really big one. DUI sentences and you're not telling people. We had a case where a PTA was sneaking Suboxone drugs into an envelope and through a pen through an envelope and through a pen through an inmate. We've had that happen. And again, I've told you about the spider veins. I've also was called in as an expert consultant on this case, and not a witness, but a consultant, to the nursing board. We had a person that had neglected, there were some nurses that had neglected a 12-year-old girl in Memphis, and when she had gangrenous, both legs were gangrenous. The parents really didn't seek medical attention. Home health nursing didn't really step up to the plate to do what they needed to do. Physical therapy was there. They did intervene and were part of the treatment program and plan. Come to find out, as I went to interview and to review the case in its entirety, this young 12-year-old girl died with her appendages all around the room. She died in her bed, but her appendages had fallen off in and around the room. I hate to tell you that, but the other thing is that really made this good for our profession. I was looking to see if physical therapy had done anything wrong, and come to find out, they acted the most appropriately in this whole treatment plan for this 12-year-old girl. So I was excited to see documentation was there, everything was there, critically where it needed to be, and PT, there was no violations for PT or PTA. Conviction of a felony, we've talked about that. Interfering with an investigation or disciplinary proceeding by willful misrepresentation of the facts or by use of threats. Violation or assisting or conspiring to violate any provisions of the Practice Act, rules, or criminal statute. And anything here from this one would be, there was a case here, a PTA worked in a nursing home and reported she had lost her purse. It was later found in a resident's room by a family member and turned into the director of nursing. The purse was opened in the presence of another nurse, and it contained the physical therapist's driver's license and 2 empty vials of cocaine and a straw. So that happened. The police were called in and the PTA was arrested. Additional 2 vials of cocaine were found on her person, so it was even on her. She was convicted of cocaine possession, sentenced to jail and fined. Her PTA license was completely revoked under this provision, and so those things do happen. Medicare and insurance regulations make fraud and federal crime. Fraud is a federal crime. A Tennessee PT was convicted of 26 felony counts involving fraud, extortion, and bribery, sentenced to 52 months in federal prison, ordered to pay $864,000 in restitution and fines. The PT's license was revoked. There's another case of revoking the license. Fraud and deceit in obtaining a license or in practice. Requesting and receiving or participating in dividing or transferring, assigning and rebating or refunding of an unearned fee. Charging unreasonable or fraudulent fees for services performed or not performed. The manual here just says a PTA applicant for licensure provided false information on her application. This was discovered and she was fined $1,500. Making misleading and deceptive, untrue, or fraudulent representations, promoting unnecessary devices, intervention, or service for financial gain, fee splitting for patient referral, payment or acceptance of commission on fees for services or articles that are supplied to the patients. So be careful about all of that as well. Okay. Law enforcement, government regulators, and legislative bodies are strengthening resources to combat fraud. And believe me, that is happening. Medicare has taken on their role in this piece as well. And then you have the 10 tips for protecting your practice from the National Heritage Insurance. So I encourage you to read that. The rules contain comprehensive requirements to promote truth in advertising. It's interesting here, I think this will lead us to this part. Truth in advertising, PT services. Our own board attorney at one time, Mr. Guilford, was walking down the street in Nashville. And as he was walking down the street, saw a physical therapy practice marker. It talked about chiropractor being in there, or at least chiropractic services being located in the clinic. So with all the talk back and forth between the two professions, and maybe some of the dissension that has occurred in the past, Mr. Guilford walked in and asked if he could speak to the physical therapist under this chiropractor. I meant to say it's the chiropractor's practice, not the PT. The PT just happens to be listed on the marker as being in there. He went in and asked for the physical therapist. There was no physical therapist. There was no PT there at all. So that was a violation that had to be reported to who? The chiropractor board, and we did report that. Something that came out of that was that it was the first time that a chiropractor from their board was fined $600 because of false advertising. Other false advertising, I think you already know, is in some of your phone books. Sometimes you'll read it in your newspapers. So be cognizantly aware of that, what you're reading. What are they saying that chiro can do? Maybe even what physical therapists are doing in the chiro clinic. So just make sure you're making yourself aware of that. This right here is failure to report any act or omission of a licensee or applicant or any other person which violates the provisions of the Practice Act. Complaints are filed with the Office of Investigations, and that's the link, and that's the phone number there. Again, they have their process and the way they do things. So you can do it anonymously. You can do it and give your name. I will tell you, though, just knowing what I know from what I've heard in and around the Nashville licensing board realm of things, if you place anonymous on it, sometimes it just doesn't carry a lot of weight. It will never rise to the level of number 4 or number 5 on higher investigation level. So if it's anonymous, it may get a few moments of time to look at it. It may be something that the attorney and the consultant can close pretty quickly if there's not enough information. If you list it, anonymously. Okay, issues not within board authority. Fees and or billing disputes, those are things that don't, where the board attorney and the consultant are not going to worry. They may look at it, but it may be a closed file for you. Fees and or billing disputes, insurance matters. We had someone make a complaint about an FCE that one of our providers was providing or didn't provide that day. This particular therapist did not provide the FCE at all. And this person thought we were in cahoots with the physician. They thought we were in cahoots with the insurance payer. She wanted her disability that bad. She claimed she didn't know anything about FCEs and disability, but in the bag that she brought with her, it had everything that she's learned on the internet about FCEs and disability. So she got very angry when she found out her husband couldn't come back with her while she's tested for the FCE. So since he couldn't come back, she threw her hands up and said she was going to report the clinic to ABC News, NBC News, and anybody else across the media network. So that did happen. I mean, I guess she reported it. It didn't make any waves. It didn't land anywhere. But still, people do get angry. But things like that are not going to go before the licensing board unless there's a filed complaint by the individual patient or by the individual therapist or your colleague. Okay. Other issues, employing illegal aliens, delinquency in child support, I mentioned that earlier. Defaulting on your student loans, big one. Seen a lot of that lately. I saw a lot of that in my last year as consultant on student loans. So we need to make sure that one will bite you if you don't pay your student loan back. I'll just tell you. Okay. Disclosure to patients. PTs must inform the patient of any financial arrangements connected to the referral process. PTs must disclose in writing any financial interest in products they recommend or endorse to their patients. PTs have the responsibility to ensure that the patient has knowledge of freedom of choice in the services and products. All right, now we're ready for the PT Practice Act puzzlers. And again, we'll try to go through this as best we can. You are going to take a post-test. And then once you take your post-test, you submit that to our TPTA office. And the TPTA office will then look at your test and also send you your certificate. So again, that's how we're going to handle that piece of it. But I do want to go over this because this will help you on the post-test when you do that part of it. So we'll go to the Practice Act puzzlers. So if you're treating a patient without a referral and the patient's doctor has not been notified of physical therapy services, can you continue to see the patient beyond 30 days from the initial evaluation? The answer, no. The direct access provisions in the in the Practice Act state that you cannot continue treatment beyond 30 days if the patient's doctor has not been notified of PT services. I'm now at number 2. You are a PT screening people at a health fair. A man with no specific complaints attends the fair. He wants to get in better shape, wants to know if you can help him develop a cardiovascular exercise program. Can you provide this service for him? Can you do this if you are a PTA? Yes, you may help him if you are a physical therapist. The Practice Act permits PTs to provide physical therapist assessments or instructions, including recommendations of exercise to an asymptomatic person without referral. You may not do this if you are a PTA. All right, number 3. A physical therapist new to Tennessee has started a job in a skilled nursing facility. She observes a PTA performing sharp debridement on a wound. This was illegal in her former state of residence. She asks you if this is legal in Tennessee. Is it? There's nothing in Tennessee's Practice Act which prohibits a PTA from performing sharp debridement on a wound. However, a PT must assess PTA competency and use sound judgment and delegation. Number 4. An undergraduate student who plans to go to physical therapy school is doing his volunteer observation hours in your clinic. After training him appropriately, can you let him perform an ultrasound treatment on a patient while you supervise him? And the answer is no. Volunteers may not provide physical therapy treatment to patients. Number 5. If a PTA goes to work, this is number 5, you all. If a PTA goes to work at a large hospital, she finds that another PTA at the facility is concurrently supervising 3 full-time physical therapy aides. She asks if this is illegal. Is it? You would say, no, it's not legal. Can you see the words there? Physical therapy aides. I said you could do what? 3 PTAs and 2. So no, it's not legal. The rules permit a PTA to concurrently supervise no more than the equivalent of 2 full-time aides. Number 6, an ATC provides coverage for a local high school team. He provides emergency treatment for a player with a knee injury. The physician in charge refers the patient for physical therapy to the PT clinic where the athletic trainer works. The patient does not understand why a PT must evaluate him before the ATC can provide treatment. Please explain. The treatment at the game was performed under the ATC license. An ATC working under the supervision of a physical therapist to provide PT treatment is not working under the ATC license and is subject to the rules for assistive personnel. So again, look up under assistive personnel when they're in your clinic. The PT must perform the evaluation. Number 7. A physical therapist working for a home health agency is asked by the clinical manager to supervise a home health aide. The PT is to monitor the aide's performance of skin inspection during bathing and safe transfers. Is this in violation of the Practice Act? Answer: no, it's not in violation of the Practice Act. The licensing board policy states the monitoring of home health aides by physical therapy practitioners is not in itself a violation of the Physical Therapy Practice Act and rules if no other ethical or practice violations are present. Number 8. A physical therapist is supervising 2 techs in a rehab facility. One tech is in the patient's room assisting the PT in treatment. The other tech is walking a patient in the hall right outside the partially open door of the room. The PT does not interact with the patient in the hallway that day. Does this meet the legal requirement for on-site supervision of assistive personnel? Answer: your answer would be on-site supervision requirements: continuously on-site and present, immediately available, you see them and hear them, involvement in appropriate aspects of each treatment session. The scenario meets the first 2 requirements, but does not meet the third one because the PT had no interaction or involvement with the patient. I hope that makes sense to everybody. Number 9, as a service to your patients, you sell exercise weights. You make a profit from the sales. Are you obligated to let your patients know that you gain financially from the sale of these products? And your answer would be, hopefully you know it, yes. The Practice Act states PT shall disclose in writing any financial interest in products they endorse or recommend to patients. The licensee has the responsibility to ensure that the patient has knowledge of freedom of choice in services and products. Number 10, you work for a large regional healthcare system which has its own home health agency. When recommending home health services for patients discharged from your inpatient rehabilitation setting, are you able to exclusively recommend your system's home health agency? What would your answer be for that? The Practice Act states, PT shall disclose in writing any financial interest in products they endorse or recommend to patients. The licensee has the responsibility to ensure that the patient has knowledge of freedom of choice in services and products. Number 11, a very good physical therapy student on her final clinical affiliation is treating a patient. She knows very well, is it acceptable for the supervising PT to leave 30 minutes early for a dental appointment while the student finishes the treatment patient? Finishes treating the patient. Your answer would be, drum roll, just drum roll here. No, the supervising PT must be continuously on site and present, immediately available, involved in the appropriate aspects of each treatment session. Okay. And the last question, number 12. In the new continuing competence rules coming soon, which of the following are correct? Both PTs and PTAs must have 30 hours in the 24 months that precede the licensure renewal month. Ethics and jurisprudence must be taken every license renewal cycle, which is 2 years. Only 10 hours may be acquired online. So, let's see what the answers are. All are correct. Those are correct. So now we will go back to the last couple of slides we have left for the presentation. So to summarize what we've done in in jurisprudence today. It's in your best interest, you all, to understand the Practice Act, the rules that complement and are the companion document. Know those rules also. The licensing board policies, make sure you know those. And if you want to create other things along the way for other policies in the future, it doesn't mean they can't be explored and talked about at the licensing board level. This knowledge will keep you from inadvertently violating the law, okay? If you are asked to do something illegal by an employer, knowledge of these documents arms you, I mean the knowledge of all of this, arms you so that you can work with the employer to change their practice. Hope that makes sense to you. Understanding the Practice Act rules and licensing board policies helps to support the decisions you make associated with the physical therapy practice. And then now it's your time to take your post-test, and please take your post-test. That will be online for you, and then you'll be able to submit your information to the Tennessee Physical Therapy Association. Her name is Amy Breedlove, and if you want her phone number, I've got it for you. It's 615-269-5312, or you can speak to Mara. Or Amy, either one will be able to help you in making sure you get your certificate and that they receive your post-test. There should be prior instructions on all of this prior to you signing up for taking this course today. Again, I want to thank you. Thank you for your time. Thank you for allowing me the opportunity to bring this to you. If you have questions, please do not hesitate to contact me. You'll know how to reach me through the Tennessee Physical Therapy Association as the chapter president. So I'll be glad to help you in that regard. Also, you can find me at their website, or you can find me at Holston Medical Group Rehab Services in Kingsport, Tennessee. Thank you very much, and have a great day.